Hello, everyone. It's Pam Esquire, also known as Your Law Intellect. I am your favorite lawyer here on YouTube. Thank you for everyone that has checked in the chat. I see you, CBBJ. We were chit chatting a little bit earlier. I'm not going to say your government name. I promise I'm not. But thank you so much for acknowledging who you were. Thank you so much, NFL Wife 18. Y'all been in here. You guys have been having a whole conversation, waiting on me to come on. I see Linda. Hey, Tasha. Silent Sister, Renee. Lady D. Sarah said, hey, Style by Stevie. Hey, hey, hey. I have a friend, Style by Stevie, that always calls me Pammy Pam, and it just reminds me every time you say that. But thank you so much for checking in. Thank you, Fred. Thank you for checking in. I see you guys. I see you guys. Thank you so much. So you guys saw the topic. The topic is, remember this $20 million lawsuit that Whitehead filed against, it was King Jives and it was Larry Reid back in September. Well, there was all this speculation about folks dodging service and all of that. Well, a month or so ago, I guess, to quell all of those rumors, as you can see, and I'm going to show you guys, Larry actually had his lawyer accept service on his behalf. So he may not have never even seen the lawsuit, but he still told his lawyer, go ahead and take care of it. So as you see, it says waiver of service, acceptance of service to process. The undersigned hereby waive service and accept service of the following on behalf of the defendant. So he was never personally served. I saw people saying things such as, you got caught and you were running, but it looks like he was never personally served. He just gave his counsel permission, as I told you guys before, that people are able to do. You give your counsel permission to accept on your behalf, so that you can just do what you need to do and do what you have to do in the lawsuit. So yeah, we have a complaint. I don't think I ever went over Larry's. I know that I did go over. Thank you so much to Cash Apps coming in. Thank you so much. Thank you so much. Um, Back in when this was first filed and we saw it in the paper, I had the documents and I had Jives on the show at the time, and I also had a client that I represented for defamation that came on the show, and we talked about defamation just a tad bit, but I was staying away from it because I kind of knew what the argument would be in response to this lawsuit if a response was filed. If you know he continued with this lawsuit, so I just kind of stayed away from it. But I never actually put the lawsuit up that I recall on Dr. Larry Reid. So we're going to go over the lawsuit on what it says for those that never have seen this lawsuit except for seeing it in the New York Times or other magazines and articles. And then we'll go over the response, y'all. And the response was some good legal reading, and it was also very informative, and it'll probably help other YouTubers. So we're going to read the entire response. So let's go over go over what was filed in the first place. Let's start with that. And I don't know why it looks like this. I promise y'all this is how it was when I downloaded it. So I have no clue why it comes out looking, I don't know. So it was Whitehead against Larry Reid and Larry Reid Live LLC. So it has the plaintiff, Lamor Whitehead, also known as the plaintiff or the Bishop Whitehead, is an individual and presiding pastor of Leaders of Tomorrow International Brooklyn Ministry Corporation in Brooklyn. Defendants are Larry Reid, got him as Mr. Reid. No Dr. Reid, just Mr. Reid. An individual and Larry Reid Live LLC, LRL, a limited liability company, blah, blah, blah. So they'll be hereinafter collectively referred to as the defendants. On July 25th, 2022, Mr. Reid wrote online that Bishop Whitehead, quote, scammed people out of money with a question mark, end quote. On August 3rd, 2022, Mr. Reid said online, Bishop Whitehead, quote, will be locked up in about 3 months, end quote. Mr. Reid's above statements spoken and written concerning Bishop Whitehead are false. Mr. Reid's statements expose plaintiff to public contempt, ridicule, aversion, and or disgrace. Mr. Reid's statements imply criminal activity and injured plaintiff's reputation as a pastor. Did you say it's already getting on your nerve? Cupcake. Come on now. Mr. Reid's false statements were published online and seen or heard by thousands of people. Mr. Reid made the false statements in a grossly irresponsible manner without regard for the truth. Let's move it up a little. As a result of Mr. Reid's conduct, plaintiff lost business deals, church members, and income. Mr. Reid committed the acts above in the course and scope of his work on his company, LRL. LRL is vicariously liable for the above alleged conduct of Mr. Reid, who is under his employ. Mr. Reid and LRL are liable to plaintiff for defamation, libel per se, and slander per se. Wherefore, plaintiff demands a trial by jury and judgment against defendant for actual and punitive damage of no less than $20 million or such other amount to be proven at trial. So that is the complaint that was filed for those that never saw it and only saw a reference to it on other YouTube channels or in other articles. This is what the $20 million lawsuit looks like. And if you've seen Jaws, it's pretty similar. It's not very long. If you saw, I also went over on a previous video, the DJ, Miss Jones, as well. And we went over her response on a couple of videos if you guys want to check that out. And of course, we responded with a motion to dismiss the lawsuit. And we went over a statute that New York has and other states have as well. It's called the Strategic Lawsuit Against Public Participation, also known as SLAPP. So it's called an anti-SLAPP. And what the purpose of this statute is to prevent people that basically attempt to use the legal system as a way to kind of stop free speech. So they allow you, instead of answering the complaint, you can file one of these SLAPP motions and basically say the whole purpose was basically to stop my freedom of speech, and they don't have a substantial basis. We'll go through all of that. And you also have to prove malice when it's considered a SLAPP type of a lawsuit. So basically, these statutes, a lot of states started these because you had, like, for instance, big corporations, like when cigarettes came out, and you had all these allegations against the dangers and the health risks of cigarettes. A little old me who may have a little bit of money, but I'm an advocate, I may go out with my sign and say, this causes A, B, C, D, and E, and I think it's unhealthy. Well, that causes financial problems for businesses, even though it may be true. So you will have corporations that will come and sue the little guy. And then, of course, people would stop talking because you don't want to get sued and you can't afford a lawyer. So a lot of these statutes started popping up in various states, and New York is one of them. New York's has expanded because I know at one point, I believe it only applied to public hearings and getting licenses, I think, for property or like for your stores or something like that. I can't remember because all this is law school stuff, so I don't even remember. But just to give you guys a general idea of what the purpose of this is. So you respond and you'll see the term SLAPP a lot of times, because this is basically a perfect example of where you would try to file this as a response. So right now, guys, before I get started, my girl Really B TV over there, I need you guys to go over there and subscribe to her. She's 100 people away, or subscribers. I said 100 people, 100 subscribers away from getting to her 10,000 goal. So if you guys would do me a favor and just, hit that subscribe and say you came over here. She also has shouted me out a lot. If one of the mods could put her channel in the chat, that would be great before we get started, because this reading right here is some good reading and we're about to get into it. You said I offered to go in the ring with him for $1 million. He didn't respond. Y'all mods, put really BTV's information in the chat. You can put it in there too. Really be, just give us a link to your channel. Because we a little lazy. We may not we just want to hit a link. So let's get into it though. So of course, like I said, there was a response that was filed. And this is your table of authorities. Let me go to the cover page. So essentially, this is a memo of law in support of defendants, which is Larry Reid and Larry Reid Live's motion to dismiss. Yes, guys, get the likes up, get the subscribes. Come on now, I'm giving you good content now. Thank you again for the cash apps. I appreciate your girls over here working hard. So right here, we have the table of contents. And then we have the table of authorities. Remember, I told you guys my professor, Neville Ewell, always said, where's your authority? So that means you're going to see a lot of case law in here to back the arguments up. So let's get started. The preliminary statement is Lamor Whitehead, a flamboyant online preacher and internet personality, was the subject of national headlines in July 2022 after being held at gunpoint in his Brooklyn church on a Sunday morning and robbed of millions of dollars in jewelry he was wearing, all in the midst of a live stream of a church service. Those who took interest in this bizarre crime quickly discovered that Mr. Whitehead wasn't your average preacher. In 2008, Mr. Whitehead was convicted in New York of multiple counts of identity theft and fraud and sentenced to prison. The same year, in a separate case, Mr. Whitehead was convicted of using a stolen identity to obtain a car loan and sentenced to prison. While he wasn't incarcerated for these crimes, he was engaged in conduct that resulted in civil judgments. He has a slew of unpaid judgments pending against him dating from 2009, 2020, and 2021. And on December 2022, Mr. Whitehead was indicted in the Southern District of New York on counts of wire fraud, attempted extortion, and false statement. He is awaiting trial. In July and August of 2022, Dr. Larry Reid, a Christian minister and influencer, discussed Mr. Whitehead on several videos, and one, the title questioned whether Mr. Whitehead had scammed people out of money. Dr. Reid is also accused of predicting that Mr. Whitehead would be locked up again in 3 months, although no content can be located showing that such a statement was actually made. Mr. Whitehead filed this libel lawsuit against Dr. Reid and LRL, claiming $20 million in damages stemming from these alleged statements. The complaint should be dismissed as a matter of law for at least 3 reasons. First, the statements are not actionable because they are substantially true. Second, the statements are not actionable because they are rhetorical hyperbole. Third, Mr. Whitehead cannot show by clear and convincing evidence that the statements were made with actual malice. Moreover, this lawsuit is a textbook SLAPP suit, a strategic lawsuit against public participation. Mr. Whitehead must therefore satisfy a heightened burden in opposing this motion under CPLR 3211 sub G. By bringing this meritless lawsuit, Mr. Whitehead is subject to a mandatory award of attorney fees as well as additional sanctions under CPLR 8303A. Factual allegations, the church robbery. On July 24, 2022, Mr. Whitehead and his wife were robbed at gunpoint while he was preaching during his Sunday morning church service, which was being live streamed, the viral video. According to news reports, Mr. Whitehead, a quote showy pastor, was robbed of more than $1 million of jewelry, including his watch, multiple chains, his wedding band, and necklace. And that's attached as Exhibit A. The story garnered national attention both due to the bizarre circumstances of the robbery and due to Mr. Whitehead's troubled past. Days after the robbery, Mr. Whitehead held his own press conference, which was attended by the media, a clip of which is shown below. As you guys see the picture there, the Bishop Lamor Whitehead press conference on July 29, 2022. At the press conference, reporters questioned Mr. Whitehead about his past, including a lawsuit filed by an elderly woman accusing him of stealing $90,000 from her retirement savings. Days after the press conference on July 31st, Mr. Whitehead, dressed in a Gucci suit, reenacted the robbery during his Sunday morning service, a performance that was also live streamed and reported by media, as shown in the screenshot below, taken from the New York Post. You guys remember that picture? And then there's footnotes on where you can find this information. To the extent Mr. Whitehead wanted the world to take notice, his press conference and robbery and reenactment worked. The mainstream national news, as well as thousands of people with social media platforms, began discussing Mr. Whitehead, his past, and the possibility that the robbery was staged. For example, by narrowing YouTube videos to the week following the press conferences and searching for Bishop Whitehead robbery, more than 400 videos are displayed, including coverage by ABC, the New York Daily News, the New York Post, Essence, and CBS. See Exhibit C. Even Mr. Whitehead's own attorney, who filed this very libel case, posted a video discussing the matter, a screenshot of which is shown below, during which he stated that the FBI had, quote, two open investigations on Whitehead, end quote, and that his, quote, prediction was that, quote, by the end of the year, Mr. Whitehead would be, quote, subject to an indictment of some sort, end quote. And there's the picture from the video. My. All right, let's proceed. And then there's the clip for anybody that wants to write that, to see that, and the timestamp from when his lawyer was on this person's show. Mr. Whitehead's frauds and judgment. Prior to the robbery, Mr. Whitehead was engaged in numerous fraudulent activities, some of which resulted in convictions, while others were widely reported but not yet prosecuted. In 2000, well, yet is in parentheses, prosecuted. In 2007, Mr. Whitehead pled guilty in New Jersey to receiving a 9mm semi-automatic handgun that he knew was stolen property. He was not sentenced until March 8, 2013 for 114 days with credit for time served. And that's in state of New Jersey versus Lamor Whitehead Miller. They have the docket number. In 2008, he was convicted in New York of scheme to defraud, multiple counts of identity theft, and attempted grand larceny. Exhibit E. As a consequence, he was sentenced to a term of 10 to 30 years in prison, where he served approximately 6.5 years in prison and was ordered to pay restitution. Around the same time, he was convicted for criminal possession of stolen property in the third degree. After the jury found that a motor vehicle recovered from his possession was obtained by using the stolen identity of a Tennessee resident to obtain a loan from Capital One Auto Finance, on which no payments were ever made. People v. Whitehead, 4883rd 237. He was sentenced to 1 year in prison. According to an article published by the New York Post, Mr. Whitehead raised funds for a youth mentorship program that he touted as a collaboration with the NYPD. The program didn't exist. That's Exhibit F. It also turns out that Mr. Whitehead is subject to numerous unpaid civil judgments, including one for $260,000 stemming from an unpaid personal loan. That's Exhibit G. He is accused of failing to pay back campaign loans and campaign workers after his failed run for Brooklyn Borough President. Footnote 6, a lawsuit pending in Brooklyn Supreme Court alleges that Mr. Whitehead convinced a former parishioner, Pauline Anderson, of giving him her entire retirement savings of $90,000 to invest, only to discover he stole the money. Footnote 7, Exhibit H. And when a newspaper visited Mr. Whitehead's home in New Jersey, the reporter discovered a notice of default of $4.5 million taped to his door. Exhibit I. The 2022 indictment. After the robbery on December 15th, Mr. Whitehead was indicted in the United States District Court, Southern District of New York, with allegations of wire fraud, attempted extortion, and false statements, Exhibit J. The criminal charges stem from the $90,000 theft of the parishioners' money, as well as for alleged use of threats of force to get $5,000 from a businessman. He was arrested on December 19th, as reported by the New York Times, Exhibit K. What's in the footnotes, just kind of where you can find all of the different cases. Dr. Reid discusses Mr. Whitehead. So now we get to the crux of this alleged defamation. Dr. Larry Reid is a Christian minister, gospel singer, and social media influencer who hosts a YouTube channel called Larry Reid Live, which has been visited more than 25 million times. In his coverage of the Whitehead robbery, Dr. Reid made a 4-minute video in which he discussed the robbery. The title shown above Dr. Reid's face during the video was, quote, "The church robbery, pastor scam people out of money." The screenshot can be seen below, and a clip from the full video is posted on Facebook and can be accessed via the link in the footnote. So this is the cover, the statement that was made, and it was actually the title of a video that they're saying was made, the alleged defamatory statement. During the video, Dr. Reid referred to the video as his, quote, commentary, as we see in the caption. So they made sure that they had closed captioning on, which shows that he said that it was his commentary, and discussed his suspicions about Mr. Whitehead, stating that, "I know people that he has taken hundreds of thousands of dollars from this year." Dr. Reid was, of course, referring to Pauline Anderson, who had a pending lawsuit filed against Mr. Whitehead, and which matter became the subject of the federal indictment that issued later in 2022, Exhibit H. During one of Dr. Reid Live's show, Whitehead requested to join the LRL platform and join Dr. Reid on the show. Mr. Whitehead immediately became irate, fat shaming Reid's guests, calling Dr. Reid ugly, and waging homophobic slurs against him. The interaction between Reid and Whitehead went viral, and the exchange clearly indicates that Mr. Whitehead has a great personal animosity towards Dr. Reid. Now we get to the complaint. You guys with me so far? You said. All right, y'all. Thank you, Tasha. Yeah, y'all, if you want to bless your girl, there goes the information. So let's get to the complaint. On September 2nd, 2022, Mr. Whitehead filed a present complaint against Dr. Reid, alleging defamation per se, and slander, and seeking $20 million in damages. The claims are based on two alleged statements made on or about July 25th, 2022 and August 3rd, 2022, that Bishop Whitehead, quote, scammed people out of money, and that Mr. Whitehead will be locked up in about 3 months. These statements will be referred to collectively as the Reid statements. Dr. Whitehead claimed, Dr. Whitehead, oh wow. Mr. Whitehead claimed in his complaint that the alleged Reid statements connoted criminal activity, injured plaintiff's reputation as a pastor, and were made in a grossly irresponsible manner without regard for the truth. As a result, Mr. Whitehead claims he lost business deals, church members, and income. The argument. So this is the legal argument where we talk about the anti-SLAPP statute. Dr. Reid seeks dismissal of the complaint for failure to state a claim pursuant to CPLR 3211, the anti-SLAPP statute. In November 2020, New York expanded the protection for defendants in defamation cases by expanding the definition of actions to which the anti-SLAPP statute applies. She also has a footnote for anybody who wants to click on the link and see where the exchange happened that the attorney was referring to. All right. Section 76A 1A of the Civil Rights Law, as amended, defines an action involving public petition and participation as any communication in a place open to the public or public forum in connection with an issue of public interest, or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest, or in furtherance of the exercise of the constitutional right of petition. The statute further directs public interest shall be construed broadly and shall mean any subject other than a purely private matter. The scope of the subject matter may be which may be considered of public interest has been defined in the most liberal and far-reaching terms and includes all types of factual education and its historical data or even entertainment and amusement concerning interesting phases of human activity in general. And then there's the case law. In light of the extremely broad interpretation of what qualifies as public interest by New York courts, cases where the subject matter was not a matter of legitimate public concern are extremely rare. And there's some more case law. Here, the Reid statements were made online on Dr. Reid's social media and concerned Mr. Whitehead during the height of an intense public inquiry into a high profile robbery and the pastor victimized by it, who himself provoked the media frenzy with press conferences and a public reenactment of the robbery. Mr. Whitehead's character was the subject of more than 400 videos in a single week, including many by mainstream national press. Exhibit C. The Reid statements are plainly in a public forum and in connection with an issue of public interest. Thus, the anti-SLAPP statute applies. Because this action is governed by the anti-SLAPP statute, Mr. Whitehead must demonstrate that his complaint has a substantial basis. He also must come forward with clear and convincing evidence that the purportedly libelous statements were made with knowledge of their falsity or with reckless disregard of whether they were false. So that's language for malice. In other words, Mr. Whitehead must provide evidence that Dr. Reid made the statements with actual malice. Notably, the anti-SLAPP statute provides for a mandatory award of attorney fees to a prevailing defendant. So right here we have the arguments. The complaint must fail because the Reid statements are substantially true. The statements at issue in this lawsuit are non-actionable because they are substantially true. Falsity is an essential element of a defamation claim. And there's the case law. Indeed, the complaint must be dismissed where the statements in question are substantially true. If an alleged defamatory statement is substantially true, a claim of libel is legally sufficient and should be, dismissed. The Reid statements, to the extent they were capable of being construed as provable facts, were substantially true. As set forth in detail above, Mr. Whitehead is a convicted felon who is now under indictment and who has been the subject of numerous unpaid civil judgments that make clear that Mr. Whitehead has stolen money, stolen identities, and trafficked in stolen goods. Merriam-Webster defines a scammer as, quote, a person who commits or participates in a fraudulent scheme or operation, end quote. Mr. Whitehead, therefore, is, by definition, a scammer. To the extent using such a phrase as a factual statement, the statement is true. Dr. Reid's prediction that Mr. Whitehead would be, quote, locked up in about 3 months, end quote, also turns out to be true. Of course, such a prediction was hardly a statement of fact that could be actionable, but even if it were, it was an accurate prediction. About 3 months after Dr. Reid made his prediction, Mr. Whitehead was federally indicted and then arrested in December 2022. Because Dr. Reid's statements were true or substantially true, the complaint fails. Y'all with me? You said not the definition. Yes, when you do a lot of the legal analysis, when you do these type of briefs, there is case law that tells you if it's the most notable term, what we know it as, and you use the definition. That's in the dictionary. We do it all the time. You said they did not come to play. Butchie Wifey said, I've heard nothing but facts so far. Okay, well, we're going to go to the second part, which says that even if it wasn't factual, or substantially true, rather. Let me get my words right. The statements are non-actionable opinion. So the law is clear that opinions, no matter how offensive, cannot be subject to libel claims. And it gives you the case law. Guys, we went through that and what that means. Whether a statement constitutes fact or opinion is a question of law for the court to decide, considering the following three factors. Sub I, whether the statement and issue has a precise, readily understood meaning. Two, whether the statement is capable of being proven true or false. And three, whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers that what is being read is likely to be opinion, not fact. Assertions that a person is guilty of, quote, blackmail, fraud, bribery, and corruption have, in certain contexts, been understood as mere non actionable rhetorical hyperbole or vigorous epithets. And that's in 600 West 115th. You guys see all the citations. In considering defamation claims involving the internet and social media, New York courts have noted that the culture of internet communication has been characterized as encouraging a free-willing, anything goes writing style. Therefore, epithets, fiery rhetoric or hyperbole advanced on social media have been held to warrant an understanding that the statement contained therein are vigorous expressions of personal opinion rather than the rigorous and comprehensive presentation of factual matter. Thus, New York courts have consistently protected statements made in online forums as statements of opinion rather than fact. There's more case law. That's the authority. And they got some samples in here of what basically a summary of what the case stood for. So in the matter of Woodbridge structure, it says they stood for the proposition. They found that disgruntled tone and use of statements on consumer grievance website that cannot be definitively proven true or false support finding that challenge statements constitute non-actionable opinion. Readers give less credence to allegedly defamatory remarks published on the internet than to similar remarks made in other contexts. And then they have also Sandal Resort v. Google, noting that bulletin boards and chat rooms are often the repository of a wide range of casual, emotive, and imprecise speech. Here, a Facebook video on social media during which Dr. Reid stated that it was his commentary was titled "The Church Robbery Pastor Scam People Out of Money." The language is colloquial and the forum one that was casual and not entirely credible. The title is overlaid above a video in which Dr. Reid unequivocally provides his personal opinion on Mr. Whitehead's integrity. Viewing the alleged statements in the context in which they were made, a reasonable person would understand that Dr. Reid included the title as part of his opinion of Mr. Whitehead. Similarly, to the extent Dr. Reid stated a belief that Mr. Whitehead would be, quote, locked up in about 3 months, this was a prediction. No reasonable person would believe that any person's attempt to predict the future would be a, quote, fact. The Reid statements constitute at most epithets, fiery rhetoric, or hyperbole advanced on social media, and the statements contained therein are vigorous expressions of personal opinion rather than the rigorous and comprehensive presentation of factual matter. And there's the case law. These statements, therefore, cannot form the basis of a claim for libel. Mr. Whitehead has not properly alleged actual malice. Mr. Whitehead's complaint also must fail because he has included nothing more than conclusory allegations of fault. He states that Dr. Reid made the statements in a grossly irresponsible manner without regard for truth and nothing further. See paragraph 9 of the complaint, which we went over in the beginning. If you guys haven't seen the actual complaint, we've already talked about that. Hit that rewind button. Conclusory allegations are inadequate to support a claim of actual malice. Rather, a plaintiff is required to allege facts sufficient to show actual malice with convincing clarity. And there's more case law. Courts applying the anti-SLAPP statute have ruled accordingly. And there's some more case law to back it up. Holding plaintiff failed to satisfy a burden demonstrating substantial basis in law where plaintiff presented only vague and conclusory allegations of actual malice. Here, the complaint does not allege any facts to support a claim of actual malice. Rather, the complaint merely asserts an unsupported conclusion of gross irresponsibility. Mr. Whitehead did not allege any facts to support actual malice, let alone allegations that show actual malice with clear and convincing evidence. The complaint also fails for this reason. Attorney fees, costs, and sanctions should be imposed. Dr. Reid is entitled to mandatory award of attorney fees, and there's the statute. Dr. Reid requests an opportunity at the appropriate time to provide an itemization of his attorney's fees and corresponding attorney affirmation upon final disposition of this motion. Mr. Whitehead's complaint is so frivolous that it also falls within the ambit of CPLR 8303-A, which permits an award of costs and attorney fees against a party, his attorney, or both who are found to have commenced or continued a claim in bad faith without any basis in law or fact, and which could not be supported by a good faith argument for an extension, modification, or reversal of existing law. Similarly, conduct is frivolous and sanctionable if it is completely without merit in law and cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. Once there's a finding of frivolousness, sanction is mandatory, especially in the wake of frivolous defamation litigation. And they have the case. Here, Mr. Whitehead filed a libel action seeking $20 million in damages in a case where he had to know that the statements at issue were substantially true and clearly opinion. It could certainly be inferred that his intention was twofold. First, to seek retribution as part of his ongoing feud with Dr. Reid, see the video. And second, to capture headlines that warn the world not to speak about Mr. Whitehead's troubles with the law. Arguably, the strategy worked. Dozens of stories have appeared online with flashy headlines about this lawsuit, and nearly all of these headlines make specific references that this lawsuit seeks $20 million in damages. So they have the exhibit showing the headlines. Perhaps most troubling is that the attorney bringing this lawsuit made similar allegations in his own social media. See video link at footnote 4. Both the lawyer and his client seem more concerned with scaring off Mr. Whitehead's critics and getting subscribers and likes than with whether or not they are abusing the court, wasting judicial resources, or causing Dr. Reid tremendous expense and headache. Mr. Whitehead and his attorney should be sanctioned under CPLR 8303-A. Conclusion: the present lawsuit is a textbook strategic lawsuit against public participation. Mr. Whitehead doesn't want anyone questioning whether he has the right credentials to be a pastor. He doesn't want anyone digging up his convictions, crimes, judgments, and liens. This lawsuit was filed with that goal in mind. It must be dismissed, and the court should impose the maximum remedies allowable under the law, including the mandatory assessment of attorney fees. So let's see what you guys have to say. Yes, guys, get the likes up, Candace said receipts. Oh, God, you guys got the emojis. The only thing he has spent 20 million on is grease, petroleum jelly. Oh, my. A whole stunt queen. Queen said frivolousness. Now let's look at some of the exhibits that were attached because it was a whole. Jaleesa said, pay Larry now. Cupcake said, I hope Tasha. TK is watching. Clearly, Larry's not playing any games in these YouTube streaks. Let me get my monies up so I can have LR's attorney on speed dial. They did not come to play. Yes, he has a great attorney. He has a good team. You said all you need is a cigarette. It's not for play. Shut up, Jack. You guys are cracking me up. See, I told y'all, I just literally we got back yesterday from being out of town from my birthday. But I was like, I gotta come to y'all with this because I had to bring it to y'all. So let's go over some of the exhibits or whatever, and then I'm not gonna hold y'all. I'm not gonna hold y'all. So remember, there were Exhibit A. So this was one of the articles. Brooklyn clergyman is robbed while delivering Sunday sermon. Then they have the article. Then they have Exhibit B. Flashy NYC bishop robbed of $1 million, bizarrely reenacts jewelry heist at service. So that was the picture on the ground. They said, there go the picture again for y'all. Bishop Lamor Whitehead reenacted how he reacted when he was robbed during a sermon last week. Miller Whitehead denied that the sensational crime was part of any purported insurance scam. The robbers took a $75,000 Rolex watch, $75,000 Cavalier watch, and several crosses worth tens of thousands of dollars. That's a picture of the car. Miller Whitehead owned several luxurious items, including a Rolls Royce. I got some good close-ups here. Then this one, what was this? Exhibit C that was mentioned has Brooklyn Bishop Lamor Whitehead holds first Sunday service. So they Googled Bishop Whitehead robbery and then printed it out on what came up. Did Bishop Whitehead really get robbed of $1 million? Bishop Whitehead, the New York Daily News. Bishop Lamor Whitehead says after $1 million Brooklyn church. So they got all of these. When you Exhibit D, State of New Jersey versus Lamor Whitehead. So that's the case. Let's see. Exhibit E, the transcript. Remember, you guys, we went over the transcript before. This is the sentencing transcript on the case where he did the prison time for. So they attached the transcript. Let's see. Ooh, this is long. They have the whole transcript. I don't think we ever went over the whole transcript. Okay, we're at Exhibit F. Beat boost fibbing felon. This was a New York Post, October 17th of 2016. I don't think I've ever read this one. An ex-con is using his close ties to Brooklyn Borough President Eric Adams to reinvent himself as a bishop, overseeing youth mentorship programs, but he hasn't left all his troubling behavior behind, according to records and associates. Lamor Whitehead, founder of Leaders of Tomorrow, Brooklyn, has appeared at more than a dozen high-profile events with Adams since his 5-year stint at Sing Sing, where he served time on multiple counts of identity fraud and grand larceny before his release in July 2013. Whitehead has used the public spotlight with Adams to tout his group's mentorship program and raise funds, but a number of Whitehead's public claims about the group have been refuted, including by law enforcement agencies. The Brooklyn District Attorney's Office sent Whitehead a cease and desist letter on November 2014 after he promoted a collaborative justice initiative with the DA's office that didn't exist. There was never any partnership or initiative together with him and this office, DA spokesman Oren Yaniv told the Post. The NYPD and Brooklyn Chamber of Commerce also counterclaimed by Whitehead that they were partnering with his group on specific initiatives. Recently asked outside his church about the specific programs run by his mentorship program, Whitehead first responded to the Post by repeating, "Why you want to know that?" He emerged a few hours later and spoke of a mentorship program where kids can shadow different NYPD officers. NYPD spokesman Lieutenant Grimpel said there was no such program. So that's the article. Exhibit, then we got Exhibit G. That is the Maximo Bogado Darman. This was a judgment, a civil judgment against Whitehead. I'm sure we went over that in a previous video somewhere. Exhibit H was the Pauline Anderson verified complaints. Let's see. We went over that in previous videos. And Exhibit I is another article. Brooklyn pastor pleads for sympathy in wake of sermon robbery, won't discuss debts. A Brooklyn pastor robbed at gunpoint of his pricey jewelry, lashed out at the media on Friday for digging into his criminal and financial history in the wake of the traumatic incident, even as he declined to answer questions about people who say he owes them money. They include not only a parishioner who alleges in a pending lawsuit that Whitehead bilked her of her life savings, but also the developers who sold him his $1.6 million house in New Jersey, who won a court judgment against Whitehead last year for more than $335,000 that still has not been paid. The New Jersey judgment hasn't been previously reported. Bishop Lamor Whitehead said he was looking for more empathy after three gun-toting robbers entered his Canarsie church during the sermon on Sunday, where he said they pointed guns at his head and at the head of his 8-month-old daughter. The three masked men clad in black allegedly robbed Whitehead and his wife of hundreds of thousands of dollars in jewelry, though he insisted reports that the items were valued at $1 million were false. My wife has not stopped crying. My daughter has not stopped crying yet. My members have not stopped crying yet, Whitehead 44 said at a press conference patrolled by 5 members of the NYPD outside Leaders of Tomorrow International Church. Nobody's empathizing with my church. At one point, tears streaked down Whitehead's face as he described the helplessness he felt over his inability to protect his family and his parishioner. "I was looking at my daughter with the gun in her face, 8 months old," said Whitehead, "and daddy could not save her because if I moved, a lot of lives could have been gone." He urged that pastors, including those with criminal records, be allowed to legally carry firearms for self-protection. And without naming any news outlets, Whitehead also said probing into his finances reeked of racism. "Why do we always got to tear black men down?" he said, adding, "As soon as a black man has a tailored suit, he's a criminal." Okay. That goes on about that. Exhibit J, we have the indictment. We went over that. And then Exhibit K, Brooklyn pastor arrested on charges of defrauding a member of his flock. So it must be an article on the indictment. And then Exhibit L, I guess it shows how the headlines were Bishop Lamor Whitehead $20 million lawsuit against critics. So they basically had something to show on the facts that were presented. You said, you know what? You are on one, Cupcake. Reid's attorneys are on fire. They did not come to play. No, ma'am, no, sir. He said this Negro is currently lying to his 9-person Bible. Tell folks he's blessed to know the Bible. He's on Bible study now. Let's see what else. I ain't seen that girl crying. So I hope you guys, enjoyed today's live. If you have not done so, please like, please share, please subscribe. Let everybody know that we have the response to this $20 million lawsuit. Everybody was saying that Dr. Reid was running from, but clearly he actually said, here, I'm waiving service. Just give it to my attorney and let them handle it. So, guys, got anything else to say? I mean, I don't think it's anything else for us to say. Thank you, Tasha. I appreciate it. You said Nick Cannon. My stomach is Nick, my stomach is Yes, please watch from the beginning. We went over the $20 million complaint and then we went over Reid's response. And yeah. So now what happens is the judge is probably going to give a date for a hearing. You have some judges that actually rule on the motions, but either way, the other side, he has the ability to respond and he has to respond to this lawsuit. Either they'll have a hearing date or you'll have the judge that just rules on the pleadings. And then the judge will make a decision whether they're going to throw the case out or if not, if they feel like the anti-SLAPP doesn't apply or for whatever reason, then the case will continue like how it does just in normal litigation. And then he would have like a certain amount of time to answer the complaint because this was a motion to basically dismiss the complaint. So the way this is set up, you can do that as your first response. But if the judge denies your motion, then you have to come back and actually answer it. So thank you, Maria. I appreciate it. Thank you, thank you, thank you, thank you. All right, guys. So we'll be back. I had there was a few one and maybe two. I'm starting to get it all confused. There was another motion that was filed that the government responded to on Whitehead, but we'll probably talk about that another day, or we'll wait till something else happens so we can do it like two motions in one day instead of just a separate live. But because we were going to go over the complaint and the motion on this defamation stuff with Reid, that's why I wanted to just do it all in one. So you guys have a good night. If you guys have not seen, what's the name of that show? The accused, innocent or guilty on A&E. It comes on at 9 o'clock. That is a good show. I really do like that show. That's why I had to make sure I came on before that came on. Yeah, so that's the show I'm going to be watching. It actually follows attorneys. I just heard my husband told me I was a nerd because I do like I listen to trials. Like we were on vacation, so we traveled to different states, and I was listening to trials in the car, and I was like, regular people just don't do that. I was listening to trials. I would listen to like CNN and MSNBC. I didn't think that was nerdy. I just really like enjoy my craft, and I like to see other people and how they write. I like to see how they argue. I like to see how they present it on both sides. So that show actually follows a real attorney. Like it follows a real attorney that's preparing for a case and about to go to trial. And there's actually been times where they were found guilty and not guilty. It's real. It's real. It's a real reality show. And like what the attorneys go through and the stress that you have. Because like I tell a lot of people, when I did criminal defense, I was more engaged because that was somebody's liberty and freedom. Like doing civil, okay, maybe if I don't get as much as I want or whatever, it's like, okay, I can't buy the new shoes or the new purse that I've been eyeing. That's different in somebody's life. So it's very, very stressful if you take your job as a criminal defense attorney seriously. Like I didn't sleep. I mean, it was a lot from a stress standpoint. So to just watch these attorneys, and they seem like decent attorneys, really guide their way through. If you guys want to kind of see a snippet of what we go through, that's a good show for you to watch. So anyway, all right, y'all. I am going to holler at you guys next time. I'm sure hopefully we'll be back sometime this week. Thank you guys for watching.